Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor, and the governor then chooses to bring it forward and deal with it as a preliminary issue, and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet, because it was apparent that what my learned colleagues were doing for the governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, and there are responses from the County Assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House and it is tested, like the Assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues, but what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the Assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1.1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1(2) then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution: Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1(3). The election of the members of Parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, as I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings, that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held not just by this House and not just by the High Court, the Court of Appeal, and the Supreme Court, that the role of the judiciary in examining impeachment proceedings arises or kicks in once the impeachment proceeding is complete. Yes, the judiciary has a role, but the judiciary then, as has been correctly held, does not have the ability to intervene at every stage. In our written submissions, Mr. Speaker, we have referred you to the relevant decisions of the Court of Appeal. We have referred you to the decision of the Court of Appeal in Kawira Mwangaza and the decision of the Supreme Court rendered earlier in the matter of Martin Nyaga Wambora. And I wish to suggest a reasoning, perhaps, why the law is as it is. Impeachment proceedings and many proceedings under our Constitution are time-bound. And if judicial intervention is allowed in some of these time-bound proceedings as they proceed, it is not clear whether the judiciary has the ability to suspend constitutional time so as to allow the judicial proceedings to proceed, or whether it is better off to allow the impeachment proceeding to proceed and be completed. And then what is taken is a process review of a completed proceeding to court. What am I saying? The correct interpretation of the doctrine of separation of powers, and it has been held repeatedly by this court, by this Senate, and by the courts, is that even where an impeaching assembly is making a mistake, allow it to complete the mistake. And what is then justiciable is the completed mistake. Don't interfere in between because of timelines, and that, I submit, is a modern interpretation of the view of the doctrine of separation of powers as to how it applies to the power of legislative assemblies, county assemblies, and this House to carry out their function of impeachment. Mr. Speaker, there was reference to a decision that was made by Kenneth Marende when he was Speaker. And it was a decision in respect to the appointment of the Honorable the Chief Justice of this Republic. And I wish to distinguish that decision from the matter that is before you for this important reason. Mr. Speaker, I have stated And I will take your permission to emphasize that impeachment are time-bound proceedings. The appointment of the Honorable the Chief Justice, yes, was a constitutional process, but it had no time limit. And the process of that appointment had the luxury of time. It could take as long as it needed to take, and it then made room in it for judicial interventions during the process of the appointment of the Honorable the Chief Justice. I have stated, and I will emphasize, that impeachment proceedings are time-bound proceedings. And if they are not concluded in time, we would then be faced with the ridiculous situation where somebody runs to court and say that Assembly X or the Senate of the Republic of Kenya did not complete their mandate in time. And I believe I was seated here a few months ago when the impeachment proceedings of the Deputy President of the Republic of Kenya were being conducted. And that was an important consideration, the strict timeline that guided many of the directions that, Mr. Speaker, you made during those proceedings. I urge you to call on that wisdom and to find, if you are persuaded to consider this as a preliminary issue, that because of the strict nature of the timelines, then the room for court or the role for court is ex post facto considerations of completed processes of impeachment. Mr. Speaker, there is a decision that has been referred to, and it is a decision that we advocates all know, and I'm glad, Mr. Speaker, you are an advocate, and I'm sure you are familiar with this decision. It is a decision that is referred to in the submissions by the Governor, and that is the decision of Lord Denning in the famous case of McFoy versus United Africa Company, where they seek to persuade, and in citing that decision, Counsel for the Governor seek to persuade you that because the proceedings are a nullity, then you should not proceed any further with these impeachment proceedings. I wish to rely on that decision, Mr. Speaker, and I wish to rely on that decision in an attempt to persuade you that it is indeed the proceedings before the High Court of Kenya in Meru that were a nullity, coming as they did, contrary to the established law and contrary to the established interpretation of the modern doctrine of separation of powers, prior to the completion of the impeachment proceedings. Those or that decision or references to that decision are a nullity, and you should disregard that decision and proceed. Mr. Speaker, I had a few passages from the decision, and Learned Counsel for the Governor seemed to be suggesting that the judge of the High Court in some way may have been directing this House as to what to do with its orders. I submit that this House is completely independent under the Constitution of the Republic of Kenya, and you should be guided properly as you then consider this preliminary issue. But in conclusion, I wish to state that this preliminary issue is not a preliminary issue. It is based on contested issues of fact, which we should then get the opportunity to look into. The second issue that I wish to respond to is an issue that when I first encountered it, I was a little concerned. And that is the submission that has been made by my learned colleagues for the Governor, and they have taken some time on it, that there were no sittings of the County Assembly of Osiolo on the 18th and the 26th of June 2025. They have used that submission in support of several grounds of their PO, and I wish to respond to that ground, and I wish to ask the House to apply it to all instances where they have made reference to the fact that indeed there were no sittings on the 18th and the 26th of June 2025. I wish to submit that that argument, with tremendous respect to the Governor and his team, is self-defeating. And it is a self-defeating argument if you look at it from this perspective. Mr. Speaker, it is the proceedings of the County Assembly of Osiolo of the 18th and the 26th of June 2025 that the Governor has taken to the High Court in Meru And it has resulted in the decision of Mr. Justice Nyaga, sitting in the High Court in Meru, which is set out, the order arising from Mr. Justice's decision is on, Mr. Justice Nyaga's decision, is on page 6 and 7 of volume 3 of the governor's document. And the ruling itself is to be found between pages 13 and pages 37 of volume 4. And having based substantive legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings nullity. I submit that they cannot. And for the completeness of the record, I submit that an estoppel arises against them approbating and reprobating in the manner in which they do. And an estoppel, for the purposes of my submission, is a legal principle which precludes a person from asserting something contrary to their previous action or statement. The contrary provision is that there were no proceedings. The previous action is that they took those proceedings to the High Court, persuaded the judge of the High Court that there were proceedings and obtained orders. They cannot do both. And for that reason, I urge you, I submit that that ground of the PO must fail. There is the issue that my good and learned friend, Mr. Theori, commenced with, and I wish to crystallize that issue as the threshold issue. The short and sharp answer to the threshold issue is that threshold, the determination of whether or not a motion surpasses the threshold required in law requires the consideration of testimony of evidence from both sides. And the consideration of evidence must of necessity, Mr. Speaker, include the testing of that evidence. There are witnesses that the governor has brought, and there are witnesses that the governor has brought and their testimony was referred to in support of this submission. We, as the advocates who are present for the County Assembly, wish to test that testimony. We do not believe that what has been stated in those statements is correct. Those facts, Mr. Speaker, are therefore contested. And if they are contested facts, they then cannot form the basis in law or otherwise for a preliminary issue. That must go on to full trial, and in the context of these proceedings, that means the hearing of the motion that has been brought. Mr. Speaker, one of the reasons that the governor gave for in support of the submission that the threshold has not been surpassed was the fact that the minutes in support of those, the Hansard, sorry, not the minutes, Mr. Speaker, in support of those two proceedings were not signed. Mr. Speaker, we note that one of the governor's witnesses is the clerk of the assembly, the County Assembly of Osiolo. Most unusual in the circumstances, because it is the clerk's responsibility to sign those Hansard proceedings. We look forward to the opportunity, Mr. Speaker, to test the testimony of the clerk and get the clerk's explanation. And we believe this House can only benefit from that explanation from the clerk. who is charged with the primary responsibility of certifying those minutes, as to his explanation as to why those minutes were not certified. The clerk is a witness. He has put in a witness statement or an affidavit, and we wish to test his testimony. Mr. Speaker, it is my submission that with the facts contested as they are, it is then difficult to use those facts to then make a determination on the preliminary issue. The next issue that I wish to submit on and emphasize is that the material that the governor wishes to rely on for his preliminary issue is the same material that the governor has brought forward, or has brought or seeks to rely on as testimony in opposition to this motion. Mr. Speaker, members of the House, I wish to refer you now to Volume 2 of the governor's response to the motion that is before you. And in Volume 2, there is the statement at page 24, and this statement runs all the way to page 32 of one Salad Buro Guracha. Salad Buro Guracha is the clerk of the County Assembly of Osiolo. As I have said, in a most unusual way, he is a witness for the governor. He makes certain averments in that affidavit, which we need to test. Those averments have been repeated by other witnesses, and it is those averments that have been relied on by my learned colleagues on the other side in support of their assertion that there is indeed a preliminary issue that requires consideration and needs to be determined as a preliminary issue. Mr. Speaker, I wish to cede the remainder of our time to my colleague, Mr. Mawira, but as I take my seat, Mr. Speaker, I wish to make the following suggestion. Mr. Speaker, it is apparent in a rather blatant manner that the issues that have been brought as preliminary issues before you are not preliminary issues, whereas they may be issues that are fit and proper for the determination of this House, but they are not fit and proper for determination as POs. My suggestion, Mr. Speaker, is that the PO be dismissed and that the governor has an opportunity then to ventilate those issues in his evidence in opposition to the motion, and that this House then makes a determination on those issues once it has had the benefit of hearing testimony from both sides, and both sides have had an opportunity to test that testimony. How much of that?